Welcome back to Court TV Live. Let's go straight to San Diego, where criminal defense attorney Brian Claypool is standing by live in front of the San Diego courthouse. Brian, so nice to have you back on Court TV.
Yeah, great to be back with you, Seema. Thanks.
Brian, I was a little shocked that when the DNA expert testified, Brian Watkins stood up and asked one question. Just one. Just one. Now, there was pretty significant testimony. There was a DNA match. Kellen Winslow, the criminalist, testified that it was 48 with 23 zeros, more likely that it was Kellen Winslow than someone unknown, which is very strong support for inclusion of Kellen Winslow in the DNA. And then, not only was that found on Jane Doe number 1's leather pants, but also there was a mixture found, okay? There was a mixture found, and in this mixture, the mixture has 3 people. Of that 3 people, one person is likely, that's a 1.4 with, I think, 28 zeros. I hope I'm not getting that wrong, but incredibly likely that it was Jane Doe number 1, which makes sense, it's her pants, and then 2 unknown individuals. So, Brian, I'm getting to my question. My point is, if you are going to argue consent, if you are going to argue that this was a case of prostitution, then why would you not dig deep, ask questions about those unknown individuals' DNA that was on this woman's pants?
See, that's a good question, but I think from the outset, Kellen Winslow II and his legal team have argued in the media as well that he did have sexual intercourse with the 3 victims in this case. So he's already been out there saying, yes, I had sex, but it was consensual, so he can't now recant from that or take that back. So in my opinion, I think his lawyer actually did a good job. One question, let's move on. Because really what this case is about with Jane Doe number 1 is, did she consent? That's really the issue.
Brian, no.
And as I'm sure you're going to get to, there was a...
No, wait, Brian, because here's my point. Here's my point. If they're going to argue consent, it seems the most likely scenario would be prostitution. And the fact that there are 2 unknown individuals, there's DNA that indicates, okay, so we don't have full profiles, and the criminalist talked about whether you can have a full, complete profile where it's like, this is Kellen Winslow, 48 with 23 zeros, or you can have some evidence of another person's DNA. And there was evidence of 2 other people's DNA on those pants. As a defense attorney, isn't it my obligation to uncover that, expound on that? Because if there's evidence of other DNA on those pants, it is more likely that she was having sex, maybe, with other people, and then we can infer prostitution from that. Doesn't a defense attorney have a responsibility to pursue that line of questioning?
Well, let me give you the counter-argument to that. The defense lawyers can still argue in closing argument that this was somebody else's DNA and that she was engaging in prostitution. The risk you run by standing up and then interrogating Jane Doe number 1 about her sex life is that a jury might now think that you're beating up on this victim and beating up on this witness, and you are terrorizing her because she's allegedly the victim. I mean, that evidence, it helps the defense, so they can still argue it in closing argument without attacking the victim on cross-examination and alienating the jury.
Okay,
so
Brian.
There is a positive side to...
Brian, I will. Trust me, Brian, you're not going anywhere, and you and I will argue a little bit later, but we got to fit in a quick break. There you go. There's a San Diego courthouse. Prosecutors say Winslow is a serial sex offender who preyed upon women who would be unlikely to report his crimes. And jurors heard from his first accuser, known as Jane Doe number 1. We have criminal defense attorney Brian Claypool live from the San Diego courthouse. Brian, thanks for sticking with us. Now, a big point of contention is that Jane Doe number 1 misidentified Kellen Winslow, actually pointed to Brian Watkins, who you know is his lawyer, in the preliminary hearing. And she discusses this today of why she misidentified Winslow. Let's take a listen to that.
At that preliminary hearing, you identified Mr. Watkins as your assailant, right?
Yes, but he shaved his head. He didn't have his hair then.
Oh, Mr. Watkins shaved his head.
No, the other one did.
The
one
Winslow
that did
did
it.
have a shaved head.
Mr. Winslow did it.
Okay. And you're certain of that?
And I was not.
Let me ask you this. Are you certain of that he shaved his head?
Yes, when I first saw him at the first time, he had a different haircut. He shaved his head.
Okay, so Brian, we are going to show our viewers a clip from the preliminary hearing, and you can see it right now. And as we can all see, that Kellen Winslow II did not have a shaved head at the preliminary hearing. He actually had quite a full head of hair. You know, is definitely at least a few centimeters off the top of his head. Looks very full, not shaved at all. Also, though, similar to the hair of his attorney, Brian Watkins. So, okay, Brian, we have seen in media coverage, in clips on Kellen Winslow, we've seen him with a shaved head. So I am wondering, is Jane Doe #1 talking about Kellen Winslow's shaved head because she's thinking of the guy on television as opposed to the guy in the courtroom?
Well, Seema, good point. But at the end of the day, it's devastating for the prosecution. I think all she should have done is, look, I made a mistake, but look, I'm 100% sure that is the guy. I mean, it's bad news for the prosecution. I mean, on this first day of testimony, I mean, get out the fire extinguisher. They're putting out big fires for the prosecution. In my opinion, the prosecution at the outset has done a terrible job of preparing Jane Doe 1 for testimony. You know that these cases, these sexual assault cases, can be won and lost with copious, intensive preparation of the witnesses. I mean, she's up there, you know, him-hawing about the misidentification, and then she says, how does she say, oh, I've been sober for 30 years? The worst absolute testimony she could have ever given. If she was prepared properly, she should have said, yes, I have drank in the past. And guess what? Then there would not be 5 prior arrests coming in for what's called impeachment evidence. And this case is going to hinge on credibility, and there's a jury instruction that I've used in California trials that says if a witness lies in one portion of his or her testimony, you can believe that they have lied in all other parts of their testimony. And the defense is going to read that instruction in closing argument.
Okay, first of all, Brian Claypool, I love your passion. I just love it, and I'm so grateful that you were on today. So thank you for that. Now, when you're talking about, because I was thinking about this morning, when you're talking about preparing a witness, okay, the bombshell that she dropped this morning was her very vivid description of Winslow's anatomy. And that is hard to reconcile with her inability to identify him in court. So how does the prosecution recover from that?
That is a fantastic point. I didn't even think of that. But you're exactly right. Again, this is all about two things, really, in a sexual assault case. Credibility of the witness, and number two, you and Chanley brought up a great point, emotion, right? Where is the emotion of a sexual assault victim? I've got 2 cases pending right now, one in Baton Rouge, Louisiana, in a civil rights lawsuit against a police officer with the Baton Rouge PD. My client, we believe, was allegedly sexually assaulted when she was inebriated after she was pulled over with her roommate on a DUI. Every time I talk to her about this case and we prepare her for depositions, she is in tears. I'm hearing Jane Doe 1 today, and she sounds like a robot. She sounds like somebody that really wasn't traumatized. And when you've got when you're asking jurors back there to decide a defendant's fate, whether you're going to send him behind bars, and you've got to weigh one witness versus another, you need a little bit more than that.
Okay, Brian, now we got to trade war stories because I have one for you. I tried a case before I left New York, and rape case, brutal rape. It occurred in the elevator of a housing project. The victim was only 18 years old, okay? Only 18 years old. She had never even had a boyfriend prior to being brutally raped. It was on video. It was in the elevator. She gets into court. She testifies, not one tear, not one. So my point is, emotion is not dispositive of the truth. We all express our feelings and our emotions and our trauma in different ways. So I don't think it is right to throw that on Jane Doe number one, that she's not emotional.
Well, I disagree with you, because I think it's not what you and I think. It's what those 12 jurors are thinking over there. And based on the description we're getting on how they're responding to Jane Doe number one, people are human. Intrinsically, they want to see that a victim of sexual abuse has been traumatized. I work on a lot of these cases, and that's the first thing you get is they see a forensic psychologist. They're diagnosed. A lot of these victims are diagnosed with what's called post-traumatic stress disorder, and they are emotional. But it's not just the lack of emotion. It's her story not really lining up. It's her describing what happened, which doesn't look like she was really coerced or threatened. You've now got some DNA evidence that suggests that maybe there's somebody else, which, believe me, jurors are going to be sitting back there thinking, what is her personal life like? Is she unsavory in other aspects of her life? I'm not attacking her, but I'm just saying, jurors are human beings. They're going to be now wondering about that, and that is going to dilute her credibility.
Brian Claypool, you are a formidable adversary, my friend. We will get back to you later on in the program. So, Brian, what does the defense have to do this afternoon with respect to Jane Doe number one, who's still on the stand?
Well, they've got to do a really detailed job of what's called impeaching her on these prior public intoxication arrests. This is a critical part of their case. This was an unexpected point. If you're this is like a heavyweight fight. So the defense was expecting to probably lose this first round today, and they actually are winning the first round because of these blunders, both with the prosecution's failure to properly prepare their witnesses, and number two, Jane Doe 1 making a colossal mistake and saying, I've been sober for 30 years. So we got about 45 seconds, I'd say, left in the first round of this heavyweight fight. So what Mr. Carlos has to do is methodically go through and say, hey, wait a minute, you told the jury this morning you've been sober for 30 years. What about this arrest? Well, you were drinking, right? It doesn't even matter what her response is. Sometimes best defense lawyers ask questions and they just want the jury to hear the question, and that really is the answer. It's not even going to really matter what Jane Doe 1 says, but this is crucial for them to then argue, like I said before the break. In closing argument, then they could say there's two times where she didn't tell you the truth. You know, one with the identifying Kellen Winslow as second, and then number two about being sober. And then then defense lawyers are gonna say you can't trust a word that she said in this case. It never happened. You can't believe her. So that's how important the cross-exam this afternoon is of Jane Doe 1.
You're so right. You can't unring a bell. And I just want to warn our viewers that we are going to continue with our very graphic analysis. There'll be graphic testimony probably this afternoon. We do have a sound bite, and this is with respect to, Brian, you're saying, you know, Jane Doe number 1 had a very explicit and graphic depiction of Mr. Winslow's anatomy, and that may go to your point of not preparing her well enough, because it was such a awkward maybe moment or uncomfortable moment that maybe the prosecution did not expect. Let's play it right now.
What did he say as he removed his leotard and pulled out his penis?
He said suck this, but I want to describe his penis, dude. It's like this big. It's not like it's this big. It's like this big. I mean, it's like gigantic. I mean, I don't know how he, oh my gosh, I just can't even believe it. I mean.
So you're describing, you're gesturing with both of your hands.
Brian, do you think that was necessary to explain it that way? And it was almost, and this is again just what I heard, it was almost very flippant, her description.
Yeah, it was not only unnecessary, but it was another devastating blow.
Okay, Brian, I'm going to ask you to hit pause. The judge is on the bench, and we are going back into the courtroom. Thank you, my friend.